All right, we're live, or so I've been told. So I'm going to jump right in here. Thank you very much for sticking with us so far. It's been obviously a great day, and very much looking forward to this legal tech panel. So let me first start off by thanking all three of you for being here today. I can feel my legal street cred rising just by the mere fact that I get to sit in on here and ask these questions with you. So thank you very much. With that said, we have a lot to get to. You can see my pages of notes here, and a short time to do it. So what we're going to do is just jump right into the introductions. Ryan, why don't you kick us off? Can you just give the audience just a bit of background on yourself and what got you interested in legal tech?
Inviting me to this conference. I think it's a wonderful conference. So my name is Professor Ryan Clements. I'm a faculty at the University of Calgary, faculty of law. I did my first law degree at the University of Alberta, graduated in 2007, practiced across most areas of securities and corporate law in a variety of capacities, big law, mid-law, boutique law. I also worked as senior policy advisor at the Alberta Securities Commission. After some years in practice, I went back to school, did my master's at Duke, focusing on fintech regulation, stayed for a doctorate where I focused on systemic risk in financial markets and financial product innovation. And now at the Faculty of Law, I teach securities, fintech law, property law, and I'm also quite active in the regulatory advisory space. I sit on committees of the Alberta Securities Commission, the Investment Industry Regulatory Organization of Canada, and actively engage with a variety of levels of government, mostly on fintech regulation. So I'm interested in tech for a lot of reasons and in a lot of ways, both from my practice experience where I've advised many tech companies through my current scholarship that focuses primarily on the intersection of technology in finance and how it's regulated. And so there's a lot of parallels to legal tech, and I hope to engage in some of those today. So thank you for the invite.
Amazing. Yeah, great to have you here. And I feel like I'm probably going to have to do this to all three of you. Ryan is also an author and entrepreneur. And most importantly, he taught me entrepreneurial law back when I was a law student at the University of Alberta, which put me on the path that ultimately led to me joining Goodlawyer. So Ryan, I'm not sure whether to thank you or to curse you at this point, but I guess we'll see how this plays out for the next couple of years. But no, seriously, if any of you U of C law students out there, even if it's not an area of interest, I highly encourage you to take a class with Ryan if you have the opportunity to do so. One of the best teachers I ever had, and just gives a very holistic look on law. And so great to have you here, Ryan. Samuel.
Thank you.
Next is you. So same thing to you. What first, just a bit of background on yourself and what got you interested in legal tech?
Yeah, so hi everyone. Thank you so much for the invitation. So I'm also a law professor, but my interest is slightly different. So I'm interested in conflict resolution and in mediation. And so before becoming a full-time academic, I was a European civil servant. I worked first for the European Commission, then I worked for the European Court of Justice, and I spent a little bit of time in a big law firm practicing competition law. So similar story, I went back to school, did a PhD in non-economics, and then I was always interested in the application of quantitative methods to the law, although at that time I was very skeptical and very critical of the application of these methods until I realized that the problem is not really with the method, but when there's a problem with the result, it's probably related to the those who developed the research and the choices they made. So eventually, and in addition, as a dispute resolution professional, I was also a little bit frustrated, especially as an inexperienced dispute resolution professional. I was frustrated with the fact that it's hard to make predictions and resolve disputes when you only rely on case law. I always felt there's a better way to resolve disputes, to make it less intuitive by relying on past negotiation, mediation, and dispute settlement agreements. So that's how I end up now at Queen's, and I'm leading this organization called the Conflict Analytics Lab, or the CAL, so it's a research consortium interested in conflict resolution and AI, and mostly we look at how how we can make conflict resolution more efficient, more transparent, more accessible by using methods, but not only, by using methods like analytics, machine learning, and deep learning, and so on. So I teach ADR and conflict resolution and law and technology, but my interest is in research, is building new technology to improve access to justice and dispute resolution.
Excellent. Thank you so much for that introduction and welcome. And I apologize for that very awkward voicemail I left you yesterday. I did not realize what time zone you were in. So hopefully we'll have a smoother conversation today. But just again, on top of being a faculty member at Queen's, Samuel is an affiliate faculty member at Harvard Law School. Yes, the Harvard. And just if that wasn't enough, also a visiting professor at Cornell University, just in case you needed an extra Ivy League school in there as well. So, but, probably many of you are thinking like me, like, okay, Samuel, you have a dazzling academic career and you've founded MyOpenCourt, but, what else do you do? Do you do anything else? And as it turns out, Samuel was also a bronze medalist at the French and UK kickboxing and taekwondo championships. So, Samuel, I think we may need to flush out exactly what you mean by conflict resolution before we jump into this conversation, because just to make sure that it is through a legal lens and not one in the boxing ring. But great to have you
different
aboard.
Perspectives on conflict resolution.
That's right. Yeah, exactly. It's you have different options. Absolutely. And then, obviously, last but not least, JP, you threw a curveball at me. I thought we were going to have you live in the studio, but same to you. Just a brief introduction and how you became interested in the legal tech space.
My name is JP Couture. I did my law degree at Ottawa U. As you might notice with the accent, I'm not originally from Calgary. Grew up in Quebec and moved out west after law school. Practiced 8 or 9 years with a large national law firm in Calgary in their tax group, but I was doing mostly a mix of corporate and tax. Had done a master previously in tax, so I was doing a mix of both. And then after 8 or 9 years, I was approached by one of the Big Four, and I started the corporate law practice for PricewaterhouseCoopers, the law firm of PricewaterhouseCoopers here in Canada. Did that for 4 years, and then while I was at PricewaterhouseCoopers, did a lot of work with technology, and we had a lot of pressure to innovate, and a lot of means as a large firm to acquire technology, and discover a different technology, discover that there was a bit of a hole somewhere in the offering, and then started Ingenio about 3 years ago. We're essentially a transaction legal tech. We're specialized around corporate record management and I would say routine transactions. So I'm doing this pretty much full time, but I still have a practice. I still practice a little bit in the area with family office. So mostly it's kind of a mix of tax, corporate, and high net worth clients and family. So yeah, so it's essentially what I've been up to in the last 15 years.
Yeah, excellent. And you've made one of the more unusual jumps from being a partner at, as you mentioned, a major law firm and a major accounting firm back into entrepreneurship, which is something that you don't often see. Anything, just very briefly, anything that triggered that for you?
That's actually an excellent question. I think I was always an entrepreneur long before joining the firms. And, I think in the last 4 years, larger firms have, you're more restricted, you're more in a little bit more in a box. And I thought it was really hard. And, that really pushed me to leave and work on the project that I'm on right now. So
excellent. Yeah. Excellent. All right. Well, let's turn to the topic at hand, which is the exciting and ever-evolving world of legal tech. Samuel, since you have the best suit today, I'm going to start with you. And I think also in the fact that MyOpenCourt uses AI technology to predict the odds of winning a dispute. My question is, how can technological advancements best be leveraged by the legal profession while still ensuring that we maintain our human touch? And again, we hear a lot about, all these innovations that are coming down the pipe, a lot of AI, a lot of machine learning, these types of things. However, the argument can be made that law is intrinsically, at least to some degree, a human endeavor. So how do we balance these two competing forces, or at least seemingly competing forces, or do you even view it that way?
Yeah, no, this is a very interesting question. So first, I mean, I very much agree with you, or I don't know if this is your opinion, but law is very much a human decision, and even the decision of judging or making a legal decision in general, legal advice, even if we're talking about the application of a simple rule to uncontested facts, it is a normative decision. And in that sense, so it's been argued that law is reflexive, and it's a reflection of many factors in society. So I don't think it is possible to, or maybe it will be, but my opinion is that there are limits, serious limits to the computability of law, but on both because technically it is complicated, and also, and I don't know if from a rule of law perspective, we actually want to hand over legal decisions to a machine. So I think and if we talk about adjudication in AI, that's where it becomes really problematic. However, when it comes to decision-making support, like MyOpenCourt, so MyOpenCourt is a legal aid system powered with AI where we predict the odds of winning a case for self-represented litigants. So in 2029, we started with employment law, and we've had about 20,000 users for the last year and a half. And just in Western Canada, so English Canada. And so mostly related to employment law question. And now we've expanded to personal injury. And then now last week, we launched a new application called the Vaccine Mediator, which is supposed to help victims of vaccine injuries to submit a claim to the Canadian Vaccine Injury Program, which is like the Vaccine Court in Canada. So in that regard, I find a few things that are quite interesting for the legal profession and for clients. So the first thing that we noticed with MyOpenCourt is that, I mean, it attracts a very different kind of users, probably some people that don't really talk to lawyers. And I'm not only talking about those, I mean, a very low income, group of clients. I'm talking also about middle income who just probably think, you know what, a lawyer is not for me. It's not good enough. I mean, I'm not going to be able to afford it. So it is interesting in the sense that it creates a new market for lawyers. So that's really the benefit for lawyers. But at the same time, also, it is great for legal information. It helps also clients to assess whether they have a case, which is probably the most important question, or it's probably the question that a lot of lawyers try to answer after the first discussion they have with their client. So in that sense, it's a good human AI collaboration, because the users will just try to find, whether they do have a case, and then eventually they are matched with a lawyer, and the lawyer has a better understanding. It's also a screening process for the lawyer, so it's interesting also from a research standpoint. It's like it's a cost-cutting decision for law firms, and at the same time for the users, it's just there's more transparency on whether it makes sense for them to hire lawyers. So I see for me this, and it's hard to predict whether technically AI and computer science will advance to the point that machine will be able to read judgments and they will be able to make a decision based on that. But at the moment, it's not possible. And then the second thing is, I don't know if we actually want that to happen.
Well, I think you touched on a great point there, is do we want that to happen? And are there lines that potentially do not need to be, or need to be respected? But just quick question, just because it's a very fascinating project, and I just recently became aware of it. And if I'm correct, it's a free tool that anyone can use. And maybe just give us a little bit of background on that. Do you have both software developers as well as lawyers working on this project to kind of combine those two? Is that how that works? Yeah.
Actually, it's also a student initiative. So it's part of my course at Queen's. So it's called the Conflict Analytics Practicum. So we created large data sets of legal cases, and we collaborate with the computer science department and data science department, actually mostly in McGill and Queen's. And we built so lawyers work with with computer science researcher to build models. So and then we deploy the model into an online open access application. So the users can predict the odds of winning a case. Sometimes it doesn't have to be winning a case. It could be a legal question like, am I an independent contractor or an employee? Am I owed minimum wage? Am I, how much termination compensation am I owed? And then if, based on a series of questions, we look at the case law, the machine looks at the case law, we'll find relevant past cases. And if the user has a decent case, they're matched with one of our partner law firms, and they just can move forward. So the first step is very much automated and mostly AI based. And the second phase is, the lawyer takes over and they bring the claim to court if they think it makes sense.
Amazing. Yeah, that's a very modern project, and hopefully we see obviously more like this coming down the pipe. JP, I'll just throw it to you. Any thoughts on the interaction between technology and the human element that obviously is still very prevalent in the legal profession?
I think I agree with Samuel. I don't see the day where I don't foresee the day where artificial intelligence is going to take over from the human mind to make the decision. But I think we're in a phase of where technology can be used to augment and improve the capability of lawyers, not replace it, not substitute it. And I think one example of that, I think a couple of years ago, Clio does this annual study. And if you look at the number of like just basic skills, like for example, responding back to clients and things like that, lawyers were scoring poorly. I think if I remember well, the figure was around 60 to 70% of lawyers wouldn't even respond to initial communication for prospective clients. So the idea there is to augment, like an idea of augmenting is to essentially help lawyer manage that flow. So by doing that, you're actually improving the human touch, because you do a first cleanup, and then you allow the lawyers to be efficient in responding and improving the human contact and having human contact. So I think this is just one example. I think there's so many areas like this where the technology can be augmented. I mean, and if you just look backward a little bit, it has, I wasn't around when lawyers were practicing and using or relying largely on fax, but there's still, if you look at the difference between fax and emails, e-signature versus, wet ink signature, and I think even with the situation during COVID this year, you can see how technology has augmented the capability of lawyers. And, in the end, it all boils down to time management and practice management, in the sense that there's, time is finite, and, there's just so much time the lawyer has in the day.
Yes.
So if that time is oriented towards doing analysis, it's better serving the clients in the end. But if that time is served doing more practice management task or simple, routine, repetitive task, then in the end, it's not good for anybody. So
yeah, and I think you hit the nail on the head. And I can tell you firsthand, when I first joined Goodlawyer, I was on the phone with a lot of the clients coming in, helping to match them with the right lawyer in our network. And one of the biggest complaints was exactly that I reached out to a bunch of lawyers, and you're the first people to call us back. And I'm not trying to put a knock on the lawyers per se, but like you said, I think that the days are just so busy, and these efficiencies hopefully can help lawyers just be able to serve more clients, because at the moment we're not doing obviously the best job, but hopefully these technologies can help us improve. Ryan, I'll get you to end this first question here, and maybe just speak to too, if you can. Are there any boundaries that we do need to be a little bit aware of when we are developing this legal tech?
Yeah, I'll lend support to what my colleagues have said here. I see it as an augmenting dynamic. Some of the existential threats, I think, are overstated. I'm on the record having published, for example, with respect to the integration of programmable blockchains, to use smart contracts to replace conventional contracts in sophisticated financial transactions. And there's a number of reasons, both in terms of ex-ante programming costs to the desirability of not locking into some form of automated logic why you wouldn't even want to use those. And so the existential threats of pushing lawyers completely out are in many ways overstated, but in some ways real. There's definitely in the process of augmenting and making legal services more efficient, there's definitely some things that are currently done by lawyers that can be done in easier, cheaper, and more efficient ways, and hopefully pass those savings on to the user of legal services. And in some ways that can form the basis of an existential threat to the legal profession, because it could lead to more jobs, and so that or could lead to less jobs or potential less profitability of certain firms. And so then that leads to a bit of a paradigm shift, which is, I think, is the time and space we're in right now, about reconceptualizing the idea of a lawyer as counselor, the nature of the provision of legal services away from maybe task-based to more broad business advisory base, and the value add that a true counselor can provide.
Right. Yeah. And I don't think you're going to get too many associates pushing back on having their doc review outsourced to an AI solution. I know I've been in those rooms, and they're not too fun. But sort of just, and I'll stick with you here, Ryan, for my second question, and sort of sticking on the same point. So how can the legal profession harvest learnings from other industries, for example, fintech, which obviously is your specialty, and apply them in practical ways to how lawyers practice or how we structure our practice? We're seeing it seems like super fast evolution in so many other areas where, and maybe it's just my perception, but there's still a bit of hesitancy at times, it seems, in the legal profession to start adopting these time-saving technologies. Any insights that you have on that?
Yes, definitely. So in framing the comparison, I want to create a bit of a separation, I guess, visually here. On the one hand, we'll use fintech. On the one hand, fintech, a lot of people think about fintech and they think about the disruptors, the new market entrants, tech firms who want to do something that a conventional bank or investment dealer or payments provider does, and they say, we can actually do this cheaper. We can pass on the savings to consumers, we can create financial inclusion, and we can still be profitable. So that's on the one side. And then on the other side of fintech, and I'll deal with both of these, there's the actual incumbent legacy institutions who are already operating in the space, who ask the question of how can we integrate technology into our current processes to enhance consumer loyalty, to compete with these disruptors on the other side, and to provide better and lower cost services and consumer welfare on this side. And so there are direct comparisons in law. You have on the one side pure disruptors, potential for legal services to be provided by non-lawyers through tech. Now, in the disruption space in fintech, the primary consideration here is actually the regulatory framework. So we're looking at things like sandboxes. We're looking at how should we regulate these new disruptive market entrants? Should we regulate them exactly the same way as we regulate banks or investment dealers? Should we provide exemptive relief to facilitate innovation? What are the risks? Is it same activity, same risk, same regulation? That largely ends up being a concern of the regulator. And you see movement in this space in fintech with respect to the regulator themselves looking at balancing innovation, support of regulatory accommodation with balancing the potential risk in this. And you see the regulators adjusting, and this is a live space. And on the legal side, when it comes to tech firms providing legal services without being a lawyer, this is where it becomes pressing on the law societies to consider this, to consider the extent that the provision of legal services can be provided by tech firms. Okay, when we start talking about the other side, which is in the fintech world, banks themselves integrating some type of a technology process to lower their cost of service and pass on the savings to the consumers. The analog here is the law firms integrating these augmenting technology processes to facilitate cheaper, better services. Now, the challenge here is actually one of incentives of the law firms themselves, because in order to do this, we need to invest. And sometimes the investment is in the long run. It's beyond the life of the partner themselves.
Yes.
They're pushing out short-term income for something that's going to provide a benefit to the firm long term. That can actually be a big friction to the take-up of these types of legal services. And it's but it's challenging. It's a challenging dynamic because you're almost at assuming that the regulator of legal services isn't going to allow these market entrants.
Right.
But the market entrants are knocking on the door of the regulator saying, hey, we have consumer welfare benefits. We have access to justice benefits. We can actually fill gaps that aren't being filled on this side. And so two things need to happen. On the one hand, the regulatory accommodation and the balancing, but on this hand, law firms being willing to invest in the future.
Absolutely.
And being willing to move away from short-termism.
And I think you touched on it, and don't even get me started, obviously, on the partnership models. We've discussed that one a few times already, but for sure, the incentives seem to be, at the end of the day, and the outward pressure saying, especially when you get these new companies coming in and saying, actually, we do have this solution and we can do this. I think that's going to put pressure on the traditional model to hopefully adapt to these. Samuel, let's turn it back to you, especially obviously you're going to take it from a bit of a different perspective, but I'd love to hear your thoughts on that, whether there's lessons learned in other industries that could be applied to kind of the traditional space here.
Yeah, actually a very different perspective, because recently my latest research project is on the vaccine and vaccine compensation, especially when related to adverse side reactions. So and I've noticed I've been looking a lot at what the health industry has been doing, and clearly they're way more advanced than we are. And one could say, but I mean, legal decisions it's probably less complex maybe than making a health decision or a medical diagnosis. And you could say as well, and the stakes also maybe a little bit lower. And the thing here is I would actually be very cautious. I've read that on a few occasions, and I think in my opinion there are a few problems with that argument. The first one is that, as I said before, law is reflexive tool, and it's very complex because it can be influenced by a lot of factors. Whereas a medical decision, for instance, is more an invariant reality. So when a doctor says you have cancer, you are like someone has diabetes, it's an invariant, it doesn't change. And you could say, okay, definitely doctors, scientists, and we've seen that with COVID, that they don't agree all the time, and actually quite a lot. They tend to disagree quite a lot. So that could be also very complex in that regard. Whereas in law, for example, determining whether someone is an independent contractor or an employee, a lot of cases are very borderline. There's a fine line. It really depends on the technique, depends on the judge. It depends also on external factor. You could say also, a bunch of employees were terminated during COVID-19, and maybe they will go to court, and the judge will decide to give a longer notice period because of COVID, and that's a reality that changes because of external factors. So when we look at this from a computer science perspective, that's really complicated. So that's why I think in a way AI is actually quite amazing to flag and identify outliers when something is slightly different. So for example, we've seen a lot of work on racial biases and so on. So for example, in the case of refugee law, if judges tend to make a decision, tend to deny claims based on the country of origin, that's a problem. Or for example, the example I was giving in employment law, if judges tend to make decisions, tend to give longer notice period in the case of an employment termination because of the economic reality. But And that's definitely not the kind of lesson we could learn from medical science, because medical science is just their reality is more invariant.
Absolutely. No, and that's, I think, a great distinction that obviously when you bring in more human factors, it's maybe a little bit less clear, and the lessons may not be able to be as easily transferred over as in some other areas. JP, last thoughts on this, and don't worry, you get the first question next time. So any thoughts on that division there?
I wouldn't even go as far as saying looking at other industries. I think it's pertinent, but I would also look at other professions. And when I talk about innovation is just not only technology. It's a whole series of practices, but also technology. I mean, the example I always give is surgeons. So there's a fairly well-known book about the use of checklists and how it has improved the rate or reduced the rate of errors for surgeons using checklists. So they did a study with about over 8,000 surgeries in 7 different hospitals, developed world, undeveloped world, or developing world. 4,000 surgery without this checklist, 4,000 surgery after a checklist, and just the use of a small checklist was reducing the errors by 34%. Mm-hmm. So when this is major, and I remember when I started practicing law, my old mentor said to me, like, essentially, law is about managing risk. Everything you're doing is about managing risk for your clients. You're managing risk through litigation, to drafting agreements, drafting documents, providing advice. So if we are about managing risk, you look at other professions and how they're managing risk in their own ways. There are things that it might not be applicable to law, but there are a lot of models that can be important in law. Like I in my career, I was lucky enough to practice in a large national law firm, and in the second biggest accounting firm in the world. And basically, there's pros and cons. And I remember at the time when I left big law, innovation was like, essentially my vision of innovation was to have more leverage. And then I got to the accounting side of things, and I saw the limit of leverage and how if not properly put in place, you can actually increase risk or, dilute the product, have all kinds of other problems. So I think lawyers need to look around, have a critical view about it, but also I think they need to reflect also on their own way of practicing and in that sense. I remember a few years back, I was at one of the ABA conference in the US, and James Sandman had done a paper on 10 reasons why law is slow to adopt technology or innovate. And I think it's pertinent just to think about them. Like, and I'm just going to quickly go through the list. So, I mean, the obvious one is the first one. It's regulatory system. Everybody's talking about it. I think it is definitely a factor, but I think in many cases, there's lots of good stories where people have managed to innovate within the regulatory system. The second one, the judicial system in Canada or in the US, for example, is fragmented. We're dealing, for corporate law, you're dealing with 14 different jurisdictions, different level of innovation. You go from, provinces where you're filing everything paper, other provinces is electronic. Mm-hmm. It's really hard when you're dealing with that. Insufficient capital for innovation. And I think this goes to the structure of law firm themselves, like the partnership are not conducive to invest capital and invest into long-term innovation. And then a pricing model. The pricing model, if you have a pricing model based on an hourly rate, it's not conducive to improving, productivity.
Right. Yeah.
The partnership, decision, it's based on consensus or as well. So it's hard to get everybody to move in the same direction. And instead of like a top-down decision where you have, executive officers that are pushing in a direction. Risk management and malpractice insurance. Like we live on empirical processes that have been developed over generations. Most law firms, my old firm had the founding firm, or the first firm was from the 1840s, and these processes have been built over time, and it's empirical how they're slowly improving, but they're not. And the way the insurance is structured is you're not encouraged to move too far out or too far away from the pack. You stay and keep the process as clean as possible, or as close as possible where everything is. legal system is based on the rule of precedence. We always look behind. We don't look forward.
Yes.
When you think about this, we're by nature, we're trained to look at what happened behind us, not ahead of us. The training also, like project management and teaching, other thing that's substantive law also is one of these factors. Also the illegal education, and very often emphasize on what I would call a lawyer judgment, and I'm sure everybody here has been the victim of it at one point, where you send an agreement to another party or a document to another party and come back and the red line is just all red, not because there was anything wrong with your document, but because the person would have written it differently, and they just, an example. And the personality of lawyers are by nature more risk adverse people. So I think we got to look at these, these are just a sample of 10 probably factors that makes it harder for lawyers to adopt, and then probably find strategy to tackle each single one of them, I think. And I think that there's no way of getting around this.
Absolutely. Yeah, there's certainly some structural issues within the legal profession, especially in North America. And I think you hit on a lot of great ones that, frankly, we could probably talk about for an hour each. But I will just give a quick shout out to you. I did read the Checklist Manifesto and highly encourage it. And it's actually a great example of taking some lessons from the medical field and applying it into law. That was a fantastic book. So for any of you who may be looking for some of those ways to integrate other lessons, you can bring it back here. But just to close off that loop there, Ryan, and we're running a touch short on time, but maybe just finish that question, which are like, what are the biggest hurdles lawyers are facing to integrating, that innovation and technology into their practice? And again, JP, you just mentioned a bunch, but Ryan, any that stand out to you?
I think that was a fantastic list. I think that was a very fulsome list, and I think that there's a lot to unpack there. I think, as I mentioned before, I don't think we can deny the fact that there's some misaligned incentives here, and that the operation of a law firm is different than the operation of a conventional corporate structure. And so the incentives to retain earnings and to retain capital for the long-term benefit of the shareholders is different than a partnership model that is looking for distribution on an annual basis. It changes the nature of the incentives. It changes the nature of what's tracked. The billable hour creates a pathology that disincentivizes long-term thinking. I think that there's the other thing that we have to think about too is like, what are the risks of increased technology adoption? Like the ex-ante training burden it puts on associates. Does that have some type of a impact where maybe as associates and young lawyers are coming out of law school? I see this in teaching students. That's the range of interests are broader now than maybe it seemed like they were when I was a 1L student. It seemed like most of us were just heading into big law, or heading into the traditional legal practice mode of delivery, where I get students routinely who are wanting to go earlier into in-house settings or outside of law or entrepreneurial or policy dynamics. And so you start wondering, like, well, if part of being a lawyer is not just meeting these heavy billable hour targets, but it's also having to learn new software that I don't get to bill on, it could be a deterrent to even taking up this area of practice. So it's an area, like you say, I hate to echo it, but it's something that deserves a more fulsome discussion that we really have to unpack. I don't think that there's a single thing that is like, this is the friction here. I think it's a compounding level of factors.
Absolutely. Samuel, kick it to you. Thank you, Ryan. Great points. Samuel, kick it to you for some final thoughts here. Maybe in your world, especially because you do seem to have that connection to the computer science departments and everything else. Maybe you're seeing a few more advancements and a loosening of this area and adopting that legal tech.
Yeah, I mean, I think it's so I definitely agree with my co-panelist. I mean, it is a problem with like risk aversion. Lawyers are more risk averse. I mean, the misalignment of interest and so on in this, that's specific to the law firm, to the legal world. However, but we need to realize that it is not only a legal problem. I mean, adoption of technology has always been a problem. And for example, IBM has been heavily criticized for investing too much in AI when it was a great technology, but then nobody wants that. They're like, yeah, great. And even now, I mean, the kind of stuff that we do, for example. So I've got projects like super computer science heavy, deep learning with computer vision for trademark and patent. But to be honest, I mean, a lot of these stuff first don't work really well. So it's a lot of very complex methods that the results are not great. Maybe they'll be great in 5 years, maybe in 6 months, maybe in 10 years. And the stuff that actually work really well, like for example, our prediction on like worker status or vaccine injury is like 95%. We use very, very basic methods. And the adoption rate is great. So sometimes we need to think also about, do we really need to go big, like super expensive technology? So that's our thing, and that's not only related to the legal field. And also, I mean, this adoption problem in the legal field, I think I encountered that when I moved to Canada a few years ago. And I was like, I was in practice, I'm just going to approach a bunch of lawyers. And I'm just going to present the idea of like, we're going to work with your data and build a system, an intelligent negotiation system. And so now when you settle a personal injury claim or you settle a employment dispute, you're going to have access to like this wealth of data on past negotiation, past employment agreements, and the case law. So what I got, like the kind of response until now, recently, and big thumbs up to BLG and FastScan, who are our first industry partner. We formalized a couple of partnership grants with them to work on their data. But like the original response was like, oh, that's wonderful, but no, we're not going to share. You're not going to work on our data. So and it's growing. And I think one solution, and as my colleague said, like there are many other solutions. I think it could go back to the legal education. I mean, and I think we law professors and law schools are kind of guilty because the law school system is very much a numbers game. Like, really, are you, what is your LSAT? What are your grades? And we don't go for like this entrepreneurial candidates. And we don't also offer a lot of law and tech or law and entrepreneurial class. And I'm not saying I'm not only talking about the regulation of technology. I'm also talking about the creation of technology, just helping lawyers to work with a digital marketing person. I mean, for example, I didn't know that what was UX designer. Most of my students didn't know what was that about. And then now they're working with one and they understand that, the button click has to be there. I mean, these are like very basic stuff, maybe for people who are not lawyers, but for us, it's a big deal. Yes. So I think this is the kind of stuff that also needs to go through education and also the way we select lawyers. I know like American law schools now, a lot of American law schools are organizing interviews for and in Canada, we still, like a lot of law schools do not have interviews. So I'm not saying all lawyers have to be entrepreneurs. I'm saying that there should be a bit of them that have a mix of both. And what my colleagues were saying what you were saying in the previous panel was like, first year people want to save the world. Third year they're obsessed with architecting position. So also, okay, so that's a labor market related problem. Maybe the market is tight and so on. But I think we also, as professors, we should really encourage that mindset. Say, yeah, do your architecting position, become a good lawyer. But maybe in a few years, if you are interested, it's a great thing. Just do something else in-house or even start your own company.
Absolutely. Very well said. And look, gentlemen, as I said in my email yesterday, I knew this time was going to pass way too fast. Thank you so much for being part of this panel. I am going to put in a final and completely shameless plug here. I knew this session was going to fly by. So if you want to hear more from our panelists, please go to the Future of Law podcast by Goodlawyer. Ryan and JP have already been on, and I see them as reoccurring guests. And whether Samuel knows it or not, he'll be a guest soon as well. So we'll definitely be able to dig a bit more into these topics. And that was, again, I know we just scratched the surface, but thank you so much for the great insights. It was a pleasure having you. And again, we'll talk soon.